Good morning, everyone. Thank you so much for joining us for today's webinar on the new policy on prohibited sexual harassment under Title IX. My name is Brandon Washington, and I am the Associate Vice Chancellor for the university's Equal Opportunity and Compliance Office. This new policy reflects our commitment to providing equal access to a safe and inclusive learning, working, and living environment, regardless of gender, gender expression, gender identity, sex, and sexual orientation. The EOC, in addition to our campus partners, are committed to serving you and helping you navigate through support and reporting options. Today, we'll be giving you some context on how the new policy came to be, how the changes affect the policy on prohibited discrimination, harassment, and related misconduct, UNC's prevention and response efforts surrounding sexual misconduct, and how to report an incident and how to get support for that incident. I'd also like to mention that we have closed caption available for this presentation. It will also be recorded and posted to our website at eoc.unc.edu. We'd also like to acknowledge that this content can be sensitive. If any of the topics discussed are triggering to you, please know that you can leave the session at any time and/or contact an emotional support person, such as the University Ombuds Office, Gender Violence Service Coordinators, or Counseling and Psychological Services. Now I'd like to introduce our facilitators for this webinar. Adrian Allison is our Director of Title IX Compliance and our Title IX Coordinator. And Rebecca Gibson is one of the Report and Response Coordinators in the EOC office. I'll now turn it over to you, Adrian.
Thank you, Brandon. Again, I'm Adrian Allison, the university's Title IX Coordinator and Director of Title IX Compliance. My job is to make sure that the university responds appropriately to reports of sexual and gender-based harassment, sexual violence, interpersonal violence, and stalking. I'm a second-generation Tar Heel. I got my undergrad degree and my law degree from Carolina, so I understand the experience of being both a student and an employee at UNC. So making sure that Carolina is a safe and equitable place for all of us is something that's very important to me. Let me give you an overview of what we'll cover in today's webinar. First, we're going to talk about what is Title IX. We'll go over UNC's sexual misconduct prevention and response. We'll talk about the new federal Title IX regulations. We'll review the university's new Title IX policy and procedures. We'll walk through a couple of scenarios to illustrate the new policy and procedures. We'll talk about how to stay informed and how to provide us with feedback. And then we'll go over some questions that viewers submitted as of yesterday evening. Please note, this webinar is not a substitution for reading the text of the university's new policies and procedures, and those can be found on our website, eoc.unc.edu. Next slide, please. Before we dive into the new federal regulations and the new policy, I want to make sure that we all have a shared understanding of what Title IX means. Next slide. Title IX is a federal civil rights law that was passed in 1972. The actual law of Title IX itself is very brief. It's one sentence, and it reads, "No person in the United States shall, based on sex, be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any educational program or activity receiving federal financial assistance." That's it. So all schools, K through 12, colleges, universities, other educational institutions that receive federal money are prohibited from discriminating against a person based on their sex. For many of our undergraduate viewers, Title IX has always been synonymous with sexual violence. However, when the law was originally passed, the focus was on making sure that female students and employees, female applicants, had equal opportunity to get in the door of education and to advance. The focus was also on equity for girls and women in sports. In the 1980s and 90s, the Supreme Court interpreted Title IX's prohibition on discrimination as also applying to sexual harassment and sexual violence. Therefore, schools have an obligation to address sexual harassment and sexual assault in order to comply with Title IX. Some courts, though not yet the Supreme Court, have also ruled that Title IX includes protection for transgender students and employees. Like all federal laws passed by Congress, Title IX is enforced by a federal agency. Title IX is enforced by the U.S. Department of Education, which then issues regulations about how schools are supposed to comply with the law of Title IX. However, the Department of Education has never, until May, actually issued federal regulations about how schools should exactly address sexual harassment and sexual violence. Instead, the department under the Obama administration issued a series of guidance documents that were very specific about how schools should respond. Those guidance documents, while they didn't have the force of law, still gave us very specific requirements. And the department has investigated many schools, including Carolina, to see if we were compliant with that Title IX guidance. In 2017, the Trump administration rescinded those guidance documents and began the process of issuing actual regulations. So those regulations, after a period of review and comment by the public, were finalized in May. As we'll discuss in a minute, these new regulations define the scope of what kind of sexual misconduct a school must address and sets out specific requirements for how schools must address the conduct that falls within that scope. Because Carolina receives federal assistance, we must comply with Title IX and those accompanying federal regulations. This means that our written policies and our written procedures about sexual harassment and sexual violence must comply with those May 2020 regulations. However, here at Carolina, compliance with federal law in this space, in the space of addressing sexual misconduct, has always been the floor. That means that we go beyond the minimal requirements in our efforts to address sexual misconduct. As we'll explain in this webinar, Carolina can be compliant with the new Title IX regulations, but still continue to address a broad range of sexual misconduct on campus and off campus that we've always addressed. And we'll continue to do so with a process that's informed by student advocacy, principles of equity and due process, and our campus values. As we transition to the next slide, I'll hand you over to my colleague, Rebecca Gibson.
Hi there, and thank you again for joining us. As mentioned, my name is Rebecca Gibson. My pronouns are she, her, hers, and I serve as one of the report and response coordinators at UNC in the Equal Opportunity and Compliance Office. Thank you to Adrienne for the overview of the federal Title IX law. I agree that it's critical for us to have this foundation in mind to make sure we are informed about what the federal law requires and to know where our campus policies come from. I want to talk with you about the evolution of Carolina's prevention and response efforts related to the many behaviors we categorize broadly as sexual misconduct. I offer this background and information to empower you to ask questions and to hold your school accountable in our efforts. As a reminder, please take care of yourself while engaging with this content today. I know this topic can be difficult for folks for a variety of reasons. Sometimes we feel our bodies reacting to this topic in real time, and sometimes our bodies react a few hours or days later. Do what you need to do for yourself this week, and I encourage you to be mindful about your physical and emotional feelings. Remember that there are resources on campus you can access through the safe.unc.edu website to get connected with support. We'll remind you about that website several times in this presentation. Next slide, please. The new regulations from the Department of Education speak only to a university's required response to the new narrow definition of sexual misconduct. We have heard from you that prevention is also important to our campus community. We as administrators recognize that prevention is critical to this work and must be critical in part to our commitment to you as students and employees. Therefore, I want to take a moment to give you a general overview of efforts surrounding prevention and support at UNC. As a result of student advocacy efforts for more than a decade, staff in the Office of Student Wellness have been dedicated to sexual and interpersonal violence prevention education for students. Those staff created the university's own evidence-based bystander intervention program called One Act. This program has expanded and evolved over the years. We recognize our prevention efforts must continue to evolve and expand based on evidence, best practices, and the needs of our student body. Our prevention efforts must continue to evolve to meet the diverse identities of our students and in recognition that sexual violence persists at UNC. We know this from the AAU survey that students completed in 2019, and we continue to use those data to inform our work. More recently, we are working to expand our prevention efforts through guidance and accountability from the Gender-Based Violence Prevention Advisory Group made up of faculty, staff, and students. The Prevention Advisory Group was convened by Vice Chancellor Becky Mangini and Interim Vice Chancellor Jonathan Sauls in June of 2020. The group recognizes gender-based violence as a complex problem that requires multi-layered solutions. Prevention must seek to change the underlying conditions and structures that enable violence, including systems of oppression. To do this, our university must establish a comprehensive prevention strategy, which the advisory group is actively pursuing. In addition to prevention, over the years, the university has grown our support resources for survivors to include 2 full-time gender violence services coordinators who provide confidential support and advocacy for survivors of all gender identities. Holly Leverne and Kayla Zollinger currently serve as the GVSCs. In their role, they offer a wealth of services to our community, including accompanying folks who are seeking formal response from law enforcement and/or the university. We do want to make sure that folks know that the GVSCs provide a critical service to our community and lend their expertise to prevention efforts. We know from the AAU survey that students who participated in the survey perceived the GVSCs to be the most useful resource, with 62.7% of respondents saying that the resource was extremely useful. We continue to work to increase awareness of this resource for our campus community, and we ask each of you watching today to visit the newly updated safe.unc.edu website to learn more about the Gender Violence Services Coordinators. Adrian will talk more in a few minutes about the formal university process for reporting sexual misconduct at UNC. I do want to acknowledge the formal process has also evolved due in part to student advocacy and nationally recognized best practices. Carolina was a leader several years ago in moving sexual violence cases from the student-led honor court to a process that now utilizes trained staff. The Equal Opportunity and Compliance Office, also known as the EOC, employs professional investigators who conduct thorough, impartial investigations, and the EOC oversees trained faculty and staff who serve on hearing panels. Perhaps the greatest example of our process evolving over the past few years was the creation of our umbrella policy that prohibits discrimination and harassment based on 13 different protected statuses. This umbrella policy prohibits harassing or discriminatory behavior based on things like sex, gender, gender identity, sexual orientation, race, religion, and other statuses. This policy was created in 2014 after a years-long process of intense work by students, faculty, and staff to create a policy that would weave together the university's values of inclusion, equity, and safety into one document and one process for responding to discrimination and harassment. This does include the misconduct we're talking about today, such as sexual and gender-based violence and stalking. The policy was critical in ensuring trained professional staff are accessible to help students and employees navigate the process, to provide supportive measures, and to investigate the reported misconduct when requested, and to adjudicate and provide remedies when it is found that an individual's behavior has violated the policy. This umbrella policy, referred to as the Policy on Prohibited Discrimination, Harassment, and Related Misconduct, embodies our commitment and community values and expectations, and grants the university jurisdiction to address a broad range of sexual misconduct. Today, this umbrella policy still remains in place, even with Carolina's new Title IX policy, which went into effect in August of 2020. We'll go back to Adrian now for more on the new policy.
Thanks, Rebecca. So what exactly do the new Title IX regulations from the federal government require Carolina to do? Next slide, please. The 2020 regulations give us a clear definition of what constitutes sexual harassment under Title IX, what kinds of behavior a school must respond to in order to be compliant with Title IX. First, we must respond to quid pro quo sexual harassment by an employee. Quid pro quo is a Latin term that means this for that. Quid pro quo harassment under Title IX is when an employee conditions a university benefit on unwanted sexual conduct. For example, a professor offering a student a better grade in exchange for sexual contact, or a supervisor demoting an employee because the employee refuses to go out on a date with the supervisor. Second, we must respond to sexual and interpersonal violence that is also covered by the Violence Against Women Act and the Federal Clery Act. That is sexual assault, stalking based on sex, and dating and domestic violence. Those terms have specific definitions that are laid out in the new university policy. Third, we must respond to any other kind of unwanted conduct based on sex that is so severe, so pervasive, and objectively offensive that it effectively denies equal access to someone's education or employment at UNC. These definitions given to us by the new federal regulations are narrower than under the existing university policy that Rebecca discussed. For example, under these new Title IX definitions, a school is not required to address quid pro quo harassment by a fellow student. School is not required to address interpersonal violence that only includes emotional abuse, or a pattern of sexual comments that might not be considered severe, but still might create a hostile environment. However, we will continue to address these types of conduct. We can, under the regulations, and we will address harassment, interpersonal violence, and other types of conduct that fall outside of this narrow scope of Title IX sexual harassment. Next slide, please. If we have information about Title IX sexual harassment, that Title IX sexual harassment has occurred, and we have a formal request from the person who has experienced the sexual harassment for an investigation of what happened, then the new regulations require that the university must formally investigate that harassment if all of the following things apply. The reporting party, that is the person who's been impacted, is a person who is participating or attempting to participate in a UNC program or activity. And that harassment that they experienced occurred in the United States. And it occurred in a location or an event or circumstances over which UNC exercised substantial control over both the context of the harassing behavior as well as the person who perpetrated the harassment. And the alleged conduct occurred on or after August 14th. All of these elements must be met for the university to be under an obligation to formally respond to the harassment by doing a formal investigation and adjudication process under Title IX. Next slide, please. If all of those elements on the previous slide are met, and the university is moving forward with a formal investigation and adjudication process, then the new Title IX federal regulations require that process to include certain elements. This slide shows a few of those required elements. First, we must provide both parties with a notice of allegations. It has to include the names of the parties, the date and location of the alleged incident. It has to include that there's a presumption that the person who is being investigated is not responsible. And it must let both parties know that they're entitled to have an advisor of their choice during the proceedings. Next, the new Title IX regulations require a live hearing in all adjudications of Title IX sexual harassment. That live hearing has to include cross-examination by a party's advisor or advocate. It requires that if a party doesn't have an advocate or advisor to do that cross-examination, that a university has to provide one for cross-examination. It also requires that in the adjudication process, a party or witness who wants to have a statement considered by the hearing panel has to be present at the hearing to be cross-examined. And it does permit hearings by video conference. The regulations also require an appeal process based on 3 specific grounds. So either party can appeal based on a procedural error, the fact that there's new evidence that wasn't discoverable before that might have an impact, or if there's conflict of interest or bias by someone involved in the process. The biggest change from our existing process is that now every case that meets the new Title IX definitions will go to a live hearing. And that live hearing will include cross-examination by an advocate or advisor. In our non-Title IX process, parties submit their cross-examination questions in writing to the hearing coordinator, who then asks the questions of both parties. Now that asking of the questions is done by an advocate or advisor. Another big change is that the hearing panel can't consider statements from parties or witnesses if the party or witness is not present at the hearing to be cross-examined. Next slide, please. The regulations require every school to adopt and publish written procedures that show our compliance with all of those elements that we just discussed. Therefore, pursuant to that requirement, the university has adopted and published a new Title IX policy. It's called the Policy on Prohibited Sexual Harassment under Title IX, and we now have written procedures that follow along with that policy. Remember, the university's existing umbrella policy is still in effect and applies to conduct that falls outside of our new Title IX policy. Next slide. If you read the university's new Title IX sexual harassment policy, which I hope you will see that it tracks the definitions in the new federal regulations. That is, it simply says that the university prohibits quid pro quo sexual harassment, sexual assault, dating violence, domestic violence, stalking, and other conduct based on sex that is so severe, pervasive, and objectively offensive that it effectively denies a person equal access to our educational programs and activities. The policy also states that conduct not meeting these particular definitions of Title IX sexual harassment may still be addressed by the umbrella policy on prohibited discrimination, harassment, and related misconduct. Next slide. So again, stepping back and looking at the big picture, the university has not changed the scope of the types of misconduct that we will continue to address. We still prohibit the same broad range of discrimination, harassment, sexual violence, including sexual exploitation, interpersonal violence, and stalking. That is, there is no difference in the what we will address. The difference is in how we will address the misconduct once the impacted person requests a formal investigation and adjudication process. Next slide. Remember that the new regulations require certain elements, most notably a hearing with cross-examination if the university is investigating and adjudicating Title IX sexual harassment, and certain jurisdictional criteria are met. That is, we've got the Title IX conduct. The reporting party is somebody who's participating or attempting to participate in our programs or activities. The alleged incident occurred in the United States and in a location or a context where UNC had some control, and it happened on or after August the 14th. Next slide, please. Also remember that we have retained our larger existing policy and process for conduct that falls outside of the narrow scope of Title IX sexual harassment. Therefore, if the reported misconduct doesn't meet the Department of Education's definition of Title IX sexual harassment, the university will apply the existing policy and will assess our response under our existing policy, which includes sexual and gender-based harassment, sexual violence, interpersonal violence, and stalking. Next slide. Rebecca?
Thanks, Adrienne. One major takeaway with these new regulations and policy we want you to hear is that Carolina, here on our campus, more is staying the same than is changing. Remember, there is really no difference in what misconduct we will address, and there is no difference in the response to an initial report of behavior, regardless of whether it falls into the new narrow definition of Title IX or into the broader existing policy. We as an institution remain committed to responding to incidents of sexual misconduct, informing parties of their options and resources and response, and supporting them through the process of their choice. When the EOC receives a report, we reach out to folks identified as impacted by the behavior and share information about resources and options. First, we do this by email, and then, if folks choose, they meet with a report and response coordinator affiliated with the EOC office. Every person is offered supportive measures. These can include connections to confidential support, like the Gender Violence Services Coordinators or Counseling and Psychological Services, medical support, a campus-based no contact order, academic accommodations, and other needs based on their specific situation. If folks choose to meet with a report and response coordinator, we will ask specific questions to help the EOC understand which policy the behavior may fall under. Ultimately, people can choose how much or how little information they want to share with a report and response coordinator. Folks are also welcome to have an emotional support person with them when they meet with a report and response coordinators. This can be the Gender Violence Services Coordinators that I mentioned earlier. Every person impacted by reported sexual misconduct Whether it falls under the Title IX policy or the umbrella policy, every person is offered information about what a formal process of investigation and adjudication by the university will look like, so that that person can make an informed choice about how they want the university to respond and to what they have experienced. Folks can choose to talk with me or another report and response coordinator to only receive support and to not pursue any additional action. It is when a person impacted by sexual misconduct asks the university to formally investigate the matter. This is when the new Title IX policy may come into play. It is then that the how the university proceeds will differ depending on whether the behavior falls into that more narrow scope of conduct the federal government now defines as Title IX sexual harassment. If it falls in this new narrow bucket, UNC is federally mandated to be compliant with those requirements. If it falls outside the narrow bucket, it will most likely still fall under the existing policy on prohibited discrimination, harassment, and related misconduct. In either the new Title IX policy or the existing policy, supportive measures are available to both parties throughout the process. And voluntary resolution continues to remain an option for folks to resolve the matter without a formal investigation. This is true regardless of which policy applies to the behavior. Next slide, please.
We recognize that this is a lot of information with a lot of definitions and terms. So to help put this information into context, we're going to walk through a couple of scenarios to illustrate the application of our new Title IX sexual harassment policy with the existing policy on prohibited discrimination, harassment, and related misconduct. Next slide, please. Scenario number 1. A student reports sexual assault while quarantined in their residence hall. And for purposes of this, we'll assume that this report occurred, or this conduct occurred after August the 14th. So in this scenario, once the EOC receives this report, a report and response coordinator, as Rebecca explained, will offer reporting and supportive measures. That is, they'll first send an email to the student with all of their resources, medical, the option to go to seek to work with law enforcement, protective orders, all of that resource information. And then the RRC will invite the student to talk with them more about what they've experienced so that we can determine what other measures might be appropriate. The report and response coordinators then will also ask some questions to determine whether or not this report would fall under Title IX. And the reason for that is so that they can explain to the party what the process might look like from here. So here we have sexual assault, which would be one of our types of conduct, that is Title IX. If it occurred after August the 14th, it would also be Title IX. Then we look at the context, and this occurred in a residence hall, which is a location over which UNC had control. And this is a student, so this is someone who is actively participating in our activities and programs as a university. So this scenario would be Title IX. This means that the EOC would inform the reporting party that if they are seeking formal investigation and adjudication, that is, if they want the university to formally address this and potentially hold the other person accountable, then we're going to be looking at our Title IX process. And so the RRCs would explain that process. They would explain to the student that there's going to be a formal notice to the other party, similar to our non-Title IX process, that there would be a live hearing with cross-examination by advocates or advisors, and that there be a determination of responsibility by a hearing panel, and that hearing panel is going to be considering statements that are made at the hearing. The EOC would also let the reporting party know that they may be able to use voluntary resolution as an option if that's something that they want the EOC to look into after the other party has been notified of the report. If the reporting party decides to move forward with our investigation process, then the EOC would formally notify the other party, and the report and response coordinators will offer to talk with that party as well about the process and about any supportive measures that party might also need. After receiving the notice and having time to respond or prepare to respond to the allegations, the responding party would be invited to participate in an interview with EOC investigators who are going to be gathering all of the information related to the incident. Both parties will have the opportunity to review all of the evidence that the investigators gather that's related to the incident, and both parties are going to have an opportunity to review a written report from the investigator that summarizes the relevant evidence. From there, the matter would go to a live hearing for a determination of whether the Title IX policy has been violated, and if so, what sanction or corrective action there should be. Remember, and I don't know if we said this earlier, that this process applies to both students and employees. So the same process here will apply if an employee, for example, is reporting sexual harassment, say at their workplace by a coworker that happened on or after August the 14th. So this scenario would fall under Title IX. We would give all the supportive resources and make sure that we have a good understanding of what's happened so that we can provide the reporting party here with information about what the process will look like moving forward under the Title IX policy and process. Next slide, Rebecca.
The second scenario presents a slightly different series of facts. We have a student who reports someone sexually assaulted them while the student was on a UNC study abroad program in Spain. The student in this situation would also receive information about resources and reporting options that would be sent to them by email from a report and response coordinator, similar to scenario 1 that Adrian went through. If the student chooses to engage with the report and response coordinator, they would have a conversation about what their needs are related to safety and access in the classroom, in their living space, and in other aspects of their life. The report and response coordinator will ask questions to assess available options, including which EOC policy may be implicated by the reported assault. We know from this series of facts immediately that the incident would not fall within the new Title IX policy because the misconduct occurred outside of the United States. This series of facts would fall within the existing policy on prohibited discrimination, harassment, and related misconduct, which applies to behavior that occurs within the university's jurisdiction, such as a study abroad program, even if it occurs outside of the United States. This student can choose what level of engagement they wish to have with the Equal Opportunity and Compliance Office. We use the language reporting party to refer to the person directly impacted by the behavior. Reporting party is synonymous with language like victim or survivor. UNC uses the language responding party to refer to the person who is said to have caused the harm or violence, the person who is accused of violating the policy and is responding to the report against them. If the responding party in this situation is a student or employee at UNC, we may be able to offer a formal investigation to potentially hold the responding party accountable for the behavior. The reporting party could decide to only receive supportive measures, or they may wish to pursue the formal process or an alternative route we refer to as voluntary resolution. The reporting party would work with a report and response coordinator assigned to their case to determine what course of action the student wishes to pursue. If they choose a formal investigation, there would not be cross-examination or a guarantee of a hearing unless there were to be a certain level of appeal to the investigation outcome. The takeaway in these two scenarios is that resources and support will always be available to folks regardless of which policy applies to the misconduct. When someone is interested in pursuing a formal university response to their experience, this is when the applicable policy will determine what formal options could look like for that individual. Folks are not expected to know these policies by heart. Myself and others in the EOC are ready to help you figure out your options. While in the US or abroad, there are several ways for folks to access information about their options. As we move to the next slide, I do want to recognize that we have touched on content this morning that may leave folks needing support and are wanting to learn more. We also realize this is a lot of information, and we want to make sure you know where to learn more about the Title IX changes and also where to seek support. Next slide, please. For more information about resources and information about discrimination, harassment, sexual violence, interpersonal or relationship violence, and stalking, please visit safe.unc.edu, shown here on the left side of the screen. This is the online UNC portal to access information about the policies we've talked about today and resources available to you throughout your time at UNC. You can learn more about the Gender Violence Services Coordinators and how to connect with them at the safe.unc.edu website. They are also a great tool to use if you are wondering how these policy changes may impact your individual options if you are considering reporting to the EOC. Folks can also connect with report and response coordinators in this EOC office to explore what their options are and what policies might apply. Myself, Adrian, and Brandon are happy to talk with you individually as questions arise. You're welcome to reach out to us for clarification and questions about the material we've covered today. The EOC website, shown here on the right side of the screen, also has a page to submit questions about these updates online. In the coming weeks, we will be working on additional information about the new Title IX policy and procedures, as well as adding additional questions on the frequently asked questions page of the EOC website. These FAQs will be informed by the questions you all submitted with your registration, as well as other questions we receive. The address for that site, again, is eoc.unc.edu. Next slide, please.
So thank you so much, Rebecca, and thank you so much for Adrian. I thought that was some great information. And to everyone that's out there, we certainly hope that this information has been valuable to you. As Rebecca mentioned, we provided individuals with an opportunity to ask questions. Obviously, we know there's some changes. One thing I do want to reiterate is, as Rebecca said, more is staying the same than it's changing, and nothing is changing about our commitment to these important issues. So we do have some questions, and I'll pose those questions, and then Adrian or Rebecca, you can certainly respond to them. The first question we have is, UNC said that there was a group who created the new Title IX policy. Who was a part of that group, and how was it convened?
A good question. So the Title IX policy itself, the policy and procedures, were drafted by EOC staff with input from the advisory group for the policy on prohibited discrimination, harassment, and related misconduct. That advisory group for our umbrella policy includes students, faculty, and staff. And so that group provided input on the policy that was drafted by EOC staff.
Thank you, Adrian. This next person has two questions about representation for parties in the Title IX hearing process. The first question is, how will UNC ensure that students have equitable access to high quality representation in this process?
So as to representation in the hearing process, the Title IX regulations require that both parties be allowed to have an advocate with them, someone of their choice. If a party does not have an advocate who can do the cross-examination portion of the hearing for them, then the regulations require a school to provide an advisor for the limited purpose of conducting that cross-examination on behalf of a party at the hearing. UNC, however, has decided that we will provide an advisor for the entire hearing process, not just the cross-examination, if a party does not already have an advocate to do the cross-examination. And the advisors will receive training, and they will be well prepared to assist a party again throughout that hearing process. The advisors the university provides, however, we recognize is not the same as having an attorney to represent someone through the investigation, hearing, and appeals. But again, we're committed to providing an advisor to be with the student during the entire hearing process.
Thanks, Adrian. The second part of the question this person asks, they say, I am extremely concerned about the new regulations. The new cross-examination policy creates issues of equity. It is already an unfair process to navigate Title IX at the university when local law offices have carved a market out of their relationships with the university to free abuse of consequences for their actions, and this policy amplifies those inequities. So more of a comment than a question. This person is just saying that they have some extreme concerns about the new regulation. So how would you respond to that?
Well, I do want to make sure that, in terms of attorneys representing students in these proceedings, that actually it's North Carolina law that says that students who are accused students who are going through judicial processes like this one are entitled to be represented by an attorney who can participate in the hearing. So that actually is something that comes to us not from these regulations, but from North Carolina state law already. That being said, we really are committed to preserving our process as being not a courtroom process, although I know some of the elements of these regulations make this process feel more like a courtroom legal proceeding. But we're really committed to preserving our process as an educational and administrative process. So in practice, what that means is we can set, expectations for attorneys and non-attorney advocates that protect the parties from, badgering questions, the kinds of, theatrical cross-examination that you might see in a courtroom, or perhaps in a TV show, is something that we can prevent in our process by really setting firm expectations about decorum and how we expect folks to treat each other in our process.
Thanks, Adrian. I have another long comment, and I'll give you an opportunity to respond. This person says, my concern is with the investigation in section 106.45B6I, specifically the consent part. Just because a person has given consent at the beginning of a sexual encounter does not establish consent for the entirety of the encounter. It is a right to take away consent, even if given prior to the interaction, to take that consent away or to change their mind if they become uncomfortable, etc. I think this change in the regulations is egregious, and to be more sensitive to the fact that the status of consent can change within one sexual encounter or between different ones with the same individual. So just kind of more concern about consent, the ability to retract consent once a sexual encounter has begun. So I'll let you speak to that.
Sure. So I think what this question is getting to is the fact that under the regulations, evidence of someone's prior sexual history is not admissible during the hearing process. That is, the hearing panel can't consider it unless it meets two specific criteria. So evidence of prior consent to sexual activity or prior, sexual activity can be potentially admissible during a hearing but for limited purpose. So I do want to explain that even though a hearing panel may have the opportunity to hear that evidence, it doesn't mean that they necessarily have to find that evidence, dispositive, right? They don't have to rely on that evidence. And I also want to make sure that folks understand that the regulations allow universities to retain our existing definitions of consent that we have developed as a community. So that means that whenever we are adjudicating, sexual violence under the new Title IX harassment policy, we're still applying our existing consent policy. And I want to make sure that everybody understands the definition of consent, Carolina. So our definition is that consent is the communication of an affirmative, conscious, and freely made decision by each participant to engage in agreed upon forms of sexual contact. And our definition includes that a person who's engaging in sexual contact can withdraw that consent at any time, and is also very clear that consent to one form of sexual contact does not constitute consent to another form of sexual contact down the line. So again, want to make sure that folks understand we're retaining our definition of consent. To the extent that a hearing panel might be allowed to consider information about prior sexual history, it has to be relevant to one of two criteria for them to even consider the information.
Thanks so much. I think that the audience really appreciated that distinction, so thank you very much. The next question is how are survivors protected under these new regulations?
So I'm not sure if this question is about protection during the investigation and adjudication process or protection more broadly. So if the person who submitted this question would like to follow up, we'd be happy to engage and unpack this a little bit more. In terms of the investigation and adjudication process, the regulations require that schools offer supportive measures. So that might include, for example, a campus issued no contact order, which would, hold someone accountable then if they did, try to have contact with the reporting party if that was prohibited by the order. So, all the regulations also still prohibit, retaliation. The regulations are, much more about the process, but in terms of protection, I would say the supportive measures and the prohibition against retaliation are still there.
Thank you. Our next question asks, how is EOC handling trainings this year? How will trainings be required and enforced moving forward in this virtual environment?
Sure. So the university still requires employees to complete training every other year about harassment prevention and response, and we're going to continue to provide that training online. In terms of our other trainings, such as the Haven training, for example. We are finalizing right now an online version of Haven, which is our program for students and employees that helps folks build skills and comfort in responding to someone who reports, sexual violence or interpersonal violence to them. So we're working on an online module of Haven, and we hope to have that open for registration soon. If there's a particular training that you have a question about, please feel free to reach out as we do this pivot to online training and education.
Thanks. We just have two more questions. So the second to last is, how much will these changes affect how we report and deal with sexual harassment, particularly when students are the victim?
I'm glad someone asked this question, because I realized we didn't touch on responsible employees in our webinar. So the new regulations don't affect how we define responsible employees, how we designate responsible employees. So the expectation for a responsible employee to report harassment to the EOC, is the same. We also, of course, appreciate and would encourage folks who aren't responsible employees, if you become aware of sexual harassment, to also report that to the EOC office. So, how information is reported to us is the same. And as Rebecca, I think walked through, our response, as the EOC is the same in terms of outreach and support. So I wouldn't worry too much about you all needing to know the intricacies of which, policy might apply. The important thing, again, is getting somebody connected to the EOC if they need support or if they want to think about formal options. And then we will take care of walking them through all of that.
Thank you. How will this information be communicated to current and incoming students in the university population?
Good question. So there was a campus-wide email that went out from Vice Chancellor Becky Mangini last month, and that email alerted the entire campus, students and employees, about the new policy. So I would say that's one way that it's been communicated. In Vice Chancellor Mangini's email, excuse me, there was a link to the new policy and a link to the page on the EOC website. We showed you a screenshot of it that will house this webinar and also has the FAQs. So that's another place where folks can get information. Then the online modules that our students are required to complete about sexual violence prevention will also have information about the new policy. And then for our incoming students, the EOC participates in orientation every year. And so during orientation for those incoming students, we'll also review this information.
Thank you so much. That's the end of our Q&A session. Before we close, I'd like to provide Rebecca or Adrian an opportunity if you want to give any last thoughts.
I would just say thank you to everyone who has participated in the webinar, everyone who has, asked questions. Please do keep the questions coming. Again, we're going to be updating our FAQ. We're going to be creating hopefully some graphics soon to outline all of this for folks. So please do keep the questions coming. Please do review the information that we have out there. And again, the takeaway is our commitment to addressing sexual harassment, interpersonal violence, and sexual violence and stalking remains the same. So we have just carved out from our umbrella policy this particular bucket, as Rebecca said, of Title IX sexual harassment. And we'll have a separate process for formally addressing that. But otherwise, our commitment remains the same.
Well, thank you all so much. And I want to say a very special thank you to Adrian and Rebecca. And as I hope folks can see, this office takes sexual violence and anything Title IX related, anything EO related very, very seriously. As Adrian said, our commitment to these issues has not wavered. I think if anything has increased. I would encourage everyone to visit eoc.unc.edu to check out our FAQs, to actually read the text of the new policy, and to submit any future questions that you may have. We want to make sure we get an opportunity to be responsive to everyone. Thanks so much to the technical team that made this possible. And again, thank you so much, Rebecca, and thank you so much, Adrian, for answering these very important questions for us. We hope to see you soon. And as a reminder, this webinar is being recorded and it will be available on our website at eoc.unc.edu. Thank you, everyone.